4th was that new countdown. No. Denied. Denied. I do not consent. StreamYard, y'all gotta bring the old song back. I don't know what that was. I do not know what that was. Hello, everybody, and welcome to the live stream. Okay, so this is getting started a little later than I wanted. I'm just gonna get through as much as I can, and we're just gonna have to catch up as we catch up, however, many exactly, however long it takes. Okay. Yes, I am back. Okay, so I was gone. I was out of the country at least for pretty much, the whole month of February. I did make a few videos. I started a new channel. There was a BJ Investigates published, stuff like that. But I really didn't. Oh man, my nose starts itching. I really did not cover the Diddy stuff at all. So I have the Diddy docket up, and I mean, I guess there's a few different ways I could do this. I think the easiest way for me to start, that I'm not going to feel like too overwhelmed and too confused, is here's the docket. I think we might have to just kind of look at it together. Yeah, so where we left off, so I'm going to probably end up jumping around a little bit, talking about some things that are more current events, and then, maybe back and forth. I might need to reference back and forth things, just looking at, like, they've changed some stuff around on this StreamYard I didn't realize, and I'm just kind of like reacquainting myself. What extra? Yeah, I know. I don't know what you're saying. The extra. Extra. I know that song. I used to like that other song. Okay. Thank you, May Knight. Hello. Shout out Monica in the chat. Shout out to Anonymous. I think I saw Birmingham Leprechaun. Shout out to you, the mods in the chat. Yep, there she is. Let's see. DJ. Hello. Busy B. K. May Knight. Tasha. Exactly on time. There you go. Yep, back again, DJ. Hey, Jessica. Julie, shout out to you. Hey, Kay. Darcy. Outro. I don't know. Girl, I don't know. Ray of Sunshine. Hello, Angie. Thank you. Okay, so here we are. Docket. I think where we left off, the last videos I made were somewhere in the range of like the 130s, 140s, 130s. I think we left off somewhere around here. Yeah, that would make sense because I think I flew out somewhere around here. So, yeah. So what was going on where we left off? I'm reminding myself too, like I said down below, it's like catch up for me as well. So let me remind myself. This 135 was the letter response in support of a motion by Diddy addressed to the judge from his lawyer, Alexandra Shapiro, not to be confused with Jay-Z's lawyer, Alexander Spiro. This was about the motion to suppress. Okay, so where we left off, what was going on from my memory and from what I'm looking at here at docket 135. Where we left off as a group, as a collective here over here on this channel, was one of the things that was being argued over was whether or not, or one of the things that was being argued over was the Bureau of Prisons search, right? The one that happened with investigator 1 involved. And then, there was this whole back and forth side story about the legal pad. And it was like someone wrote legal on it. Was the word legal written on the pad after, was it written on the pad after the search happened? You remember that whole thing? Okay. So docket number 135 is a letter from Diddy and his lawyer, Alexandra Shapiro, about the motion for a hearing. They were trying to get, and this is stuff that we did go over already, but I'm just, we're getting back on the wagon, as it were. At 1:35, this was a letter in support of Diddy and his lawyers motioning for a hearing. They wanted a hearing. They wanted basically to do a little miniature trial. So that's what 135 is, a letter in support of that. And then document 136 is a few days later, the government, the feds respond to that motion for a hearing. And then there is an order the next day from the court. So the court takes exactly one day to think about these two competing motions. But again, this has really been going on for months, this whole motion for a hearing and what do we do with the evidence, et cetera, et cetera, et cetera. So this is an order right here. It says the court is in receipt of the Fed's December 20th ex parte letter concerning certain investigative steps it took based on Combs's notes. Okay, so this is, again, this part is still just a recap. If you're here in the live chat, type recap. If you're here on the replay crew, you're watching this after it's live, you can probably fast forward a little bit because we are just, if you don't want to hear the recap of where we are, where we left off rather. And this was around the end of January 28th. So again, reminding us where we were at this time, because the purpose of this channel over here is for y'all to actually understand what's going on. And y'all can't if I don't even know what's going on. I mean, you can outside of me, but if you want me to explain it to you to understand, I got to understand it too. Okay. So I don't want to be rushed. Thank you. Not that anyone's rushing me. I mostly just say this stuff out loud for myself. So 137, this is document number 137. We're here. This was January 28th. You see the date right here. Okay, so this was an order. The judge gives an order. The judge says, all right, government, feds, I read your letter, the letter that you sent back December 20th. And to remind you what that letter was, that December 20th letter, the judge had ordered the feds. The judge had ordered the government. The judge had ordered the feds to explain themselves on a couple things about that whole Bureau of Prisons search. Okay. So in this letter, December 20th, the government had to answer certain questions. In order to, sorry, I'm just looking at a few other things. In order to proceed toward, if the judge is going to grant a hearing, if the judge is going to have a little miniature trial over this whole Bureau of Prison search thing. So as part of that, the feds had to give certain information. Some of the information that the feds had to give was pertaining to investigator one and his involvement and all that. So the judge here, basically a month later, and now sitting here today, this is about a month ago, a little bit more. The judge said, I'm in receipt of that letter. Thank you, government, for that, for those receipts, for that information. Thank you very much. It also dealt with the investigative steps that the government itself, the feds themselves, took based on Diddy's notes. Given the content of the letter, the judge says, it is unclear why the letter or the content cannot be shared with Diddy in some form. So then the judge says by January 31st, the government should either provide Diddy with a letter describing at what level of detail is appropriate, what steps were taken, or the letter should say, or number two, if no disclosure can be made, the judge is saying, I need an explanation as to why. Okay. So this, again, I don't want to get too much in the details. We got a lot to go over, but this is just to kind of, place it at where we are in the trial. It's the judge kind of giving certain orders, like the government needs to give some answers. Response to opposition. So these are all things that are, okay, so this has to do with the Bureau of Prison search. This is Diddy and his lawyers are wanting the information, some piece of evidence. And the judge is saying, I don't see a good reason why we can't give it to Diddy. So give me a good reason or give it to him. Okay. So that's what 137 is pretty much, for the purposes of understanding where we are. Same day, something else is filed, 138. This is the response by the government that the judge asked for. Let's see. Oh no, excuse me. Yes, okay. Regarding the letter. Okay, yes. Okay. So they respond to what the judge asked for the day before. And then the next day, January 29th, we have document number 139, another letter from Mark Agnifilo. 140, there's a document 140 memorandum of endorsement. Okay, so this isn't supposed to be like line by line, piece by piece. Let me just like quickly see what's going on, see if we need to read this one. Defendant's motion to amend the protective order is denied because Diddy was trying on document 140. He's always, trying to do something, it's always something going on one way or the other. So in this particular one, this particular docket entry 140 entered on January 29th. Diddy motioned to amend the protective order to, I believe, if I recall correctly, he wanted to have more access to certain things, like maybe in the jail or in his cell or something. This is just off memory. I'm not exactly sure, but the judge denied that, but without prejudice. So Diddy can bring it up again if he, has something substantial to add. The government objects to handing over certain videos. They don't want to hand over the videos to Diddy, but they provide options for Diddy to consider, many options or plural options for Diddy, how he could view the videos. So there was, and at the time, this is again over a month ago, but at the time there was kind of like some chitter chatter on social media and stuff about how Diddy wants the tapes in the prison so he can share them with his friends and he's trying to intimidate victims. I mean, this again, it was chitter chatter on the internet. The next document, 141, memorandum endorsement letter motion as to Diddy. The protective order is clear. The defense shall not share any attorney eyes only material. And this attorney eyes only material also was in the news yesterday for a different case, the Justin Baldoni and Blake Lively case, because apparently Blake Lively and Ryan Reynolds on their side of this lawsuit, this big defamation, AstroTurf trial by media lawsuit, Blake Lively and her husband, Ryan Reynolds, they want attorney's eyes only designation on like basically like third party text. Like people are speculating it's Taylor Swift and their other friends, but I mean, I don't know. So here we are in the Diddy case. This is, about a little over a month ago. Memo as to Diddy. The protective order is clear. Diddy and his lawyers and all them cannot share any attorney eye only material or the content of the attorney eyes only material with anybody. And then they cite to where the docket report is for that. The defense original letter, so Diddy's original letter, which the court ordered stricken from the public docket, did not redact numerous descriptions of the content of the videos at issue, which have been designated attorney's eyes only. Pursuant to the protective order, these descriptions are also appropriately sealed under the test. Okay, but to the extent certain of the government's proposed redactions don't relate to the attorney's eyes only material, just give me a second. I want to explain this. Just need to read it. The defense's original letter can be refiled with those specific instances. The clerk of court. Okay, so this is a judge's order, and this has to do, some of you may remember, Diddy's lawyer submitted a filing. And in the filing, it wasn't apparently, what's the word I'm looking for? Appropriately or enough redacted. So the judge said, you got to pull that up off the docket. You got to pull it off. They pulled it down off of the docket, but some people did access this document before it was taken down. So it was just kind of like filed. And then, so the judge is saying, no, I had to take that down. So you need to do the redactions. The reason you got to do the redactions is there's an existing protective order, attorney's eyes only. And here you are describing it to the freaking public. And then Diddy ain't even supposed to see it. So that's what 141 is about. Then the next day, we get docket 142, a letter filed shortly before the court's memo denying without prejudice show this motion. I mean, okay, so they had filed something, but the judge filed something else. I think this is also the government here, the feds. Basically, the judge beat the feds to it. The judge entered the order. Then the government was going to show up and say, you got to take this off the document. But it's like, okay, never mind, moot. We don't need you to do. You already did it, Your Honor. Thank you. You beat us to it. Okay. The next document, I think, is one of the more important ones that we'll probably get to today. This is S1, document S1. Now, try your best to remember this S1 because we're going to get an S2. Okay. S1 is the superseding indictment. Okay, superseding indictment 1. We've been hearing for months. I mean, basically since the first indictment, there's been chitter chatter here and there. When will we get a superseding indictment? And what that means is another indictment that is different than the first one, such that any changes made in this second one, in this superseding indictment, those are the ones that supersede. Those are the ones that are going to basically trump, right? I mean, now it's like confusing because there's the man in the White House right now, but like, I mean, the verb. Okay, so here, S1, we have the superseding unredacted indictment. Okay, so we as the public, as you can read here, let me make this bigger. The red print here, the red font, not for public view. So if you are to try and click on this document, it'll say document not available. But then you'll see docket 144. It's the same filing, except it is redacted. Okay. So this is the one that the public can view. This is document number 144. So I have downloaded that one and I'm going to pull it up now so that we can just take a look at it. I don't remember exactly how long it is, but I do know there were some notes I wanted to point out to y'all. This is superseding indictment 1. Again, like I said, there has been another superseding indictment filed. So it kind of trumps over the S1. This one's called S2. Okay. But I just want to pull up document 144. This is S1. This is the first superseding indictment. Now, a lot of people were thinking, are we going to get more names? Are we going to get more charges? Are we going to get, any co-defendants listed? These are kind of the things people were speculating. Again, this is the end of January that we're about to pull this one up. The S2, the second superseding indictment that has just came out yesterday, and March 6th. So we're going to go over that one as well. We're going to spend more time on that one because that one is superseding. This one right here, what we're about to look at, is no longer the law of the land. It's no longer the indictment. Now, what is an indictment again? Just to remind you, it's the lawsuit against Diddy by the feds, pretty much. It's like, these are what we're going after him for. What document number is 144? Superseding indictment. Okay. So this is S1. Okay, this is the first superseding indictment. Again, I'm not going to spend a substantial amount of time on it because it has now been superseded. It's now been overwritten, as it were. Okay. Similar stuff as to last time. For decades, Diddy abused, threatened, coerced women, others around him to do these things. Now, the first indictment, if I recall correctly, was substantially shorter, if I recall correctly. Maybe I don't recall correctly, but I feel like it was like about 5 to 9 pages. Or was it 18? I don't remember. It's like so many lawsuits, but this one seems like more fleshed out or whatever. Okay, so they name his businesses, kicked, dragged, the Combs Enterprises. So this is, again, I don't want to spend too much time on this one right here. It does mention the FOs. It does mention IV fluids. It starts to mention, supervisors, security staff, personal assistants, things like that. I didn't even spend that much time reading this because I was leaving to go out of the country at this time, or maybe I was already out of the country. So the racketeering conspiracy, I do think the year was broadened. It now is, instead of beginning in 2008, it's beginning in 2004. 444 in the chat, shout out to you. Same counts though, same like actual criminal statutes under which they are or were charging him on that superseding indictment. Okay, so let's pull the docket back up. That was document number 144. Wow, that was a lot of fours happening. 444 in the chat while we were on document 144. Is that true? Is that what happened? Wow. Okay. So here's the docket. That was 144. Okay, so then we're going to move on to document number 145. This one was filed on January 30th. A letter by the government or, the feds as to Diddy addressed to the judge regarding the superseding indictment. Let me see if I have that one downloaded. I don't. I'm trying to keep it moving, so I'm not going to get into that, but I will write that one down because I am interested in reading that letter, docket 145. It's a letter that accompanies the superseding indictment, and usually it kind of describes for the judge for convenience, which ends up helping the public for convenience, what basically top line 30,000 foot, what was changed, what's the main point. So there's that letter. Again, I'm trying to kind of move along so we can get as much ground covered today as possible because I like I said, I can't stay unlimited time today. Okay, so now we're on document 146, January 31st, USCA mandate on interlocutory appeal, notice of appeal. Okay, so there was some type of appeal that Diddy had filed. And on January 31st, at docket number 146, he voluntarily withdrew. So he doesn't want the appeal for whatever that thing was at the time. So I don't exactly remember. Transmission of the mandate order to district judge. Okay, interlock. Okay. So that was those two documents. Okay, so that's just Diddy withdrew an appeal. We didn't talk about that, no. He had done that somewhere else. Maybe this is just like the USCA mandate. It's some document filed in relation to that, okay? All right, document number. So then we have like pretty much not much goes on in the case for a while. That was January 31st, 2025. Nothing's filed again until February 11th. So like 12 days later. And it's an order. As to this case, the pretrial conference scheduled for March 17th is now going to be held on March 14th. Daniel Patrick Moore. Okay, so they tell you the location. At the conference, the court will also arraign Diddy on the superseding indictment. Okay, so still, I mean, not that big of a deal of a document is filed. So we do have a little bit of a lull in this case, right as I went on vacation. They went on vacation too, I guess, girl, because on January 30th, superseding indictment is filed. So big filing. Then there's a letter accompanying it. The feds are explaining kind of what's new. The next day, there's something having to do with withdrawing an appeal is filed. And then nothing happens for like 12 days, like almost 2 weeks. That's whenever there is an order that comes down from the judge, and it does two major things. First thing it does is it moves the pretrial conference. Like every so often, all the parties come together, meet up, and kind of discuss the schedule and other important things that need to be discussed. In this case, it was like, I think just the automatically scheduled pretrial conference. At that time, they're gonna, like I said, discuss. The judge really just wants to check in and make sure everything's going on time, but also there's certain things that come up during the discovery process that the judge has to kind of referee on. So they do put these pretrial conferences in automatically, but then also you can kind of request a hearing or whatever. It's kind of pretrial. Okay, so an order, February 11th, 2025, document number 147, comes down and the judge moves the pretrial conference date by only about 3 days, advances it, makes it earlier. It used to was going to be on March 17th. Then he moved it to March 14th. Another thing this document does is it clarifies that Diddy is going to face the arraignment for the superseding indictment at this hearing. It's going to happen March 14th. Now, today's sitting here, it's March 7th. So this is still about a week away from today, as of the time of this live stream. Diddy is going to be arraigned at that hearing. What is arraigned? It's where he pleads guilty or not guilty. The charges are read out to him and all of that. I assume he's going to plead not guilty That's pretty much been his pattern so far. The next day, there's an opinion and another order. All right. So the order has to do with the Bureau of Prisons sweep. Okay. So remember where we left off back in like the mid 130s of docket number, docket number 135 or so. We were talking about, and my last video before this one on the Diddy docket, we were talking about, among other things, this Bureau of Prison sweep. Diddy and his lawyers and them wanted pretty much a mistrial because of the whole thing. They took issue with the way the sweep was done. They took issue with who was involved in it. They took issue with how it was done, where it was done, when it was done, why it was how, all of it, saying basically Diddy was targeted unfairly by this. They violated his constitutional rights, all that. If he couldn't get a mistrial, he would settle for some, plan B, plan C, and so forth. The judge never had, as of the time the last video I made, the judge had not decided what he was going to do with the evidence, what he was going to do with the, whether it was going to be a hearing. And I think actually, yeah, he decided there wasn't going to be a hearing. But the judge is weighing in again on something else having to do with that sweep. Okay. In connection with the sweep, a Bureau of Prisons investigator 1, photographed 19 pages of Diddy's notes and sent them to the government's filter team. The filter team consists of assistant U.S. attorneys who are not involved in the investigation. So the filter team would have consisted of attorneys who were not involved in Diddy's case, either investigating it or prosecuting it. But, Diddy argued this is just such an unfair system, period, because these attorneys aren't just any random neutral third-party attorneys. They still are prosecutors and they work at the Southern District of New York. Okay. So the judge is saying, all right, in connection with the Bureau of Prisons sweep, this filter team received 19 pages of Diddy's notes. And who did they receive it from? Investigator 1. Okay. The case team, the filter team redacted the notes and sent them to the case team. So the judge is just kind of recapping what happened. The case team consists of the agents and the the assistant U.S. attorneys investigating and prosecuting Combs. So the filter team is allegedly, supposedly not related, not investigating Diddy, not prosecuting Diddy. That filter team, they redacted these 19 pages of notes that they had got from investigator 1. How did he get them? It was during that prison sweep. Okay. The history and the hole in the ground. The prison sweep happened. Investigator 1 takes 19 pages of pictures of Diddy's notes, sends them to filter team. Who is filter team? Filter team is these allegedly unrelated, uninvolved, but still employed by the Southern District of New York. Their job is to kind of referee this information, which like I said, Diddy has taken issue with. The filter team redacts these notes. They make a determination on what should be redacted and sends them to the case team. Now, who's the case team? The case team is the ones that are prosecuting Diddy. They are investigating Diddy. So the case team gets it from the filter team. The filter team got it from investigator 1. Investigator 1 got it from the sweep, which was allegedly, supposedly already planned and routine, ordinary course of business. Okay. Now, oh, sorry. I'm getting ahead of myself, but I'm seeing here that there was a sealed document placed in the vault. Now I'm just nosy and curious. Okay, so we're here. We're talking about the filter team, how they got it and all that. In November, the government included some of what it received from the filter team in its opposition to Diddy's bail application. So Diddy was trying to get bail. This is like lifetimes ago in the context of this case. In November, he's trying to get bail. The government includes some of the information from that prison sweep, the pictures of the notes. Diddy objected. He argued that the notes contained privileged information. They were obtained in violation of his constitutional rights. The court held an emergency hearing. I think that was on the November 19th. The court held an emergency hearing at which the government indicated, so the feds told during The feds told the judge during this emergency hearing about this notes, pictures, and all that, right? The judge held the hearing, and then the feds tell the judge, or quote, indicate, it would not rely on those notes in opposing the bail application. So, all right, Your Honor, we did include the notes. We did include the notes. But the government says, this is back in November, we won't rely on it. Just take it out. We'll just take it out. We ain't even gonna mention it. Just forget we even said anything about those. The court goes on this order. What we're reading for, if you're just getting what we're reading from, if you're just getting here, is docket number 148, which was filed on February 12th. It's an order along with an opinion from the judge. And we're just reading the summary right now because I'm trying to cover as much ground on these documents so we can catch up on as much as we can during this video. I might go back and specifically dig into some of these documents, but right now we're just doing a cursory overview. So we're doing the executive summary or whatever of the judge's opinion, and the judge is just outlining, reminding us what happened. The court ordered the case team to get rid of those notes until the judge could decide or determine later what best to do. Diddy has now filed a motion for an evidentiary hearing and other relief. So Diddy has filed a motion. He wants a whole baby hearing and other relief. Like, he was saying mistrial and suppression of evidence and stuff like that. Diddy's demands are based upon the argument that seizure of his notes violated his Fourth Amendment rights and that the government intentionally obtained his privileged communication. So he's saying it was no oopsie daisy, Your Honor. They did this on purpose. The feds on purpose violated my rights, Diddy is arguing as of, 2 or 3 weeks ago. The judge goes on, in response to the motion, the feds argued. So in response to Diddy's arguments, the government is arguing, no. There was no violations at all. Especially no violations on purpose, but just, out of an abundance of caution or whatever, so we can stop arguing about this, the government's like, we just won't offer anything from those notes as evidence in the trial. We'll just forget it ever happened. How about just let's move on. In a December 20th, 2024 ex parte letter, the government said the following. Wait, excuse me. No, okay. The contents of the letter were later shared with Diddy. The government outlined certain investigative steps. Okay, so we already discussed this December 20th letter. The judge is bringing it up again here. The government outlined certain investigative steps that the feds took upon receiving Diddy's notes. And that's these pictures, the 19 pictures from the investigator one. But the government represented again that it, quote, will not offer the evidence obtained pursuant to the investigative steps and the prosecution of the defendant. And the government further said, the Fed said, that it, quote, intends to produce the evidence obtained from the steps to the defendant to the extent it hasn't already. There was an opinion and order. Okay. So what did he order? Okay. So where this is leaving off, this is docket 148, and where docket 148 leaves off, the judge had ordered the government to provide Diddy with evidence backing up their version of the story of what happened with the investigator one. I think this would have included like maybe emails, communications, stuff like that between the investigators, emails, how the chain of custody of the documents, stuff like that. So the judge at docket 148, February 12th, 2025, he is ordering that the government, yes, it's actually official court order, boom, boom, yes, you need to tell Diddy this evidence, these communications, or whatever the evidence was. Again, docket 149 is sealed. You can't click it. It says sealed document placed in vault. Don't know what that is. The next day, there's February 13th, 2025. That's when we get docket number 150. It's a letter motion from Mark Agnifilo. This is Diddy's attorney. He wanted a day extension to file pretrial motions, or he was submitting something in regard to that. Maybe he was arguing against it. Maybe he was arguing for it. Again, we're not getting into all the specific details. I'm just trying to get an overview here. Then the next day, February 14th, there's a letter as to Diddy addressed to, so it's a letter from Diddy's attorney, Mark Agnifilo. And it's addressed to the judge, of course. And it was dated, endorsing, right on behalf of Sean Combs, the consent of the government. Okay, the one-day extension thing, the pretrial motions currently due Monday, February 17th. So this is just scheduling stuff at 1:51. Okay. Then you get something. I think this is another one of the more important documents we will discuss today. The first one was Superseding Indictment number 1, S1. Now we're getting into Diddy filing a motion to dismiss. Now he's filed a motion to dismiss. This is February 18th. Today is March 7th. So this was 2-3 weeks ago, okay? But Diddy, through his lawyers, filed a motion to dismiss. Just one count, not the whole full lawsuit. Just one count of the lawsuit, count 3. Now, this is actually a very fascinating legal argument. Diddy argues through his lawyers that this is a racist law. He argues that the very inception of the law itself has roots in racism. It was colloquially referred to as the White Slave Owner Act or something. I actually think I would like to make a separate video giving that particular document the nuanced attention it deserves, but I will pull it up for the purposes of doing the brief overview. I think we'll probably call it quits in like maybe 15 or 20 minutes. So just letting y'all know, I'm trying to kind of cover as much ground as possible. This is the memo in support of Diddy's motion to dismiss count 3. This is, hold on, what docket number is this? 153. 153, okay. This document is about, looks like it's like 13 pages in length, so probably like about 11 once you get rid of the fluff of the... Okay, as you can see, this document 153, filed February 18th. Today, again, is March 7th. Memorandum of law in support of Diddy's motion to dismiss count 3 of the superseding indictment. That's AKA S1. Here is the table of contents, which we will actually look over today because we're not going to be covering the full document. Again, put a 153 in the chat if you would like a dedicated video to this, because I'm going to go back and read this one with a little bit more attention to, detail. Put a 153 in the chat and in the comments if you would like a dedicated video to this, if you want me to do it on a video. Otherwise, I'm just going to do it myself. Table of authorities, introduction, background, argument. Okay, what's the argument? What's Diddy arguing? Count 3 should be dismissed as an instance of selective prosecution. Okay, so selective prosecution is one way to get a lawsuit thrown out, but it's very hard to prove it. I will say it's very hard. It's notoriously difficult to prove selective prosecution because prosecutors do have broad discretion to bring cases for the reasons they want. The prosecutors would also likely argue there is certain context that makes certain people more worth prosecuting, like they're very famous, they're very powerful, they're very whatever. I'm not saying I agree with these arguments, okay? I'm just saying these are things that do get argued and, ink is spilled. So Diddy is saying count 3 only should be dismissed because it's selective prosecution. And as support for that conclusion, he argues that the act itself has a troubling history of racist enforcement. And the charging decision in this case evinces impermissible bias. Okay, so impermissible bias on the behalf of the feds and racism in the act that they're charging him on in and of itself. Those two things make it an instance of selective prosecution. And since it's selective prosecution, according to Diddy, it should be dismissed. But just that count. So that's not getting rid of the whole criminal case or anything like that, although he has hinted and argued that he should get a mistrial because of that whole legal pad thing. But we're not talking about the legal pad thing right now. We're talking about something different. The Bureau of Prison sweep is behind us. It's in the rear view as of right now. This right here, document 153, is about count 3 of the superseding indictment. Okay, nothing to do with the Bureau of Prisons. He's saying he's getting targeted because it's racism and it's bias. Now, could be. I don't mean to dismiss it. Okay, could be. We'll have to see what the judge decides. It's really all that is going to end up mattering. So Diddy and his lawyers file this moderately lengthy filing. It's 13 pages. The case is unprecedented in many ways, Diddy argues, but perhaps most notably and most disturbingly, quote, no white person has ever been the target of a remotely similar prosecution. Diddy is an extraordinarily successful artist, businessman, blah, 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 blah. He started his first company based on his idea of a new business headed by a young Black executive, emphasizing Black excellence and achievement. Over the ensuing decades, he forged blah, blah, blah. Okay. This is the crux of the argument. No white person has ever been the target of an investigation such as this to this degree. Nobody that's white has ever had to face the statute being applied like this. Now, the feds do, just to, spoiler alert, they do come back and dispute Diddy's version of events. Apparently they do give some instances of this being, done to white people, celebrities, people, whatever, the statute applying in that way. Again, I do see quite a few 153s. We'll discuss 153 a little further at some point for sure. Okay. So let's go back to the docket, again, covering as much high level ground as we can today. 152 was the motion to dismiss count 3. 153 was the document we just looked at, and we'll maybe look at more. Put a 153 in the chat if you want to see that. Then there is a letter filed that same day at docket 154 by Mark Agnifilo. And this is regarding docket number 36. Let me scroll back up there and see what that is. Okay. So he's referencing all the way back to an October 15th, 2024 filing. This is docket number 36. This is a letter where Mark Agnifilo had asked from the feds for the alleged victims' names. Okay. So scrolling down to February 18th, Mark Agnifilo is pinging the judge on that issue at docket 154. At 155, Mark Agnifilo is busy today. Okay, look at all of this. There's a motion, and I should say legal team, Diddy's legal team, including Mark Agnifilo. Look at all the things February 18th. There was a lot going on, and they were big filings. Motion to dismiss, and then the memo in support of the motion to dismiss, a letter about the alleged victims' names, and then another unrelated thing having to do with proposed addendum to the protective order. Now, I do believe, and this is docket 155, this is where, is Rabbit in the chat? Shout out to Rabbit in the chat. Yep, there she is. Shout out to Rabbit in the chat. We are just here talking about this motion. This motion right here, because I think this is one of the things that ends up decided, yeah. This is another one where Diddy is trying to change the protective order. Excuse me. This is where the feds, I misspoke. The feds, the government is trying to change the protective order. Okay. And then it does look like the judge ordered something different about the protective order. Now, the protective order is the governing document that tells people in the case, the defendant, the government, the feds, the attorneys, how certain evidence is supposed to be dealt with. Is it supposed to be attorney's eyes only? That means Diddy can't see it. Definitely the public ain't supposed to see it. Is it going to get a, specific designation? Going to be regular? Is it Brady material? I mean, there's all these different ways you can classify this evidence, right? And each case gets a protective order for the case, right? It's supposed to be tailored for the case. But generally, protective orders are going to allow as much public they're supposed to allow as much public transparency as possible. There's all these things, efficiency and things like that. So, like in the Blake Lively, Justin Baldoni case, they over there arguing over so if text messages with Taylor Swift ought to be attorney's eyes only, and Justin Baldoni can't even see them. Um, I'll do a video on that too if it's still relevant by the time I can get to it. But yeah, so the judge looks like the judge did amend or quote addendum means addition. It's like something was added to it. Now, I do want to look at this one right here. I haven't had a chance to really look at the motion that Diddy's attorney filed, talking about under no circumstance can I ever be his attorney right now. This is docket number 157. It's not long. Okay, here, let me pull it up for y'all. This is docket 157. This is the document where the attorney for Diddy is begging the judge on my knees, and I'm begging to get off of this case. Okay. 4 pages. This is filed by attorney Anthony L. I guess Rico. Please take notice, Your Honor. Upon the annex declaration of this attorney that Diddy moves this court for the following relief. Okay, so first order of business I find interesting. I have not read this document yet. I had downloaded it and maybe skimmed it. I maybe had opened it, but I really haven't looked at it. This is a notice of motion. Motion to do what? For someone to withdraw as counsel. Now, in the tabloids, in the media, on social media, etc., I had heard about this incident. And the way that it was presented pretty much uniformly and unanimously was that Anthony Rico was asking the judge to withdraw as counsel. Maybe he is. He has a declaration attached. But it's interesting here. It says Sean P. Diddy Puff Daddy Combs is moving the court for the following relief for the following 1 and 2. 1, an order permitting Anthony to withdraw and anything else. Okay, so Teeny Garagos has just recently started going by her married name, and she got married a long time ago. It's interesting to me. Declaration. Here is Anthony Rico's. I don't know how to say it. Declaration. Declaration means like his affidavit. Like he wrote this. This is the attorney's words. Trying to get up off Diddy's case. Okay. Pursuant to this statute, I declare the following. On September 22nd, 2024, I was retained by Sean P. Diddy Puff Daddy Combs to serve as his lawyer. I've served as his lawyer since. As a result of being retained, I filed a notice of appearance on September 29th, 2024. This declaration, so this document we're reading right now, is submitted in support of the annexed notice of motion for my withdrawal as counsel, as is required, because he wants to withdraw. For the reasons below, this motion for withdrawal is filed. So Sean P. Diddy Puff Daddy Combs can move forward with his defense and to commence jury selection and trial without any delay. Roman numeral I, reasons to be relieved. So he's about to give his reasons. Okay. As a result of discussions with Mark Agnifilo, who's the lead counsel, this motion for withdrawal. Okay, so this is interesting. I haven't read this out there in the world. It says it's blaming discussions with Mark Agnifilo. Okay, as a result of talking to Mark Agnifilo, that is why I'm filing this motion. While I am aware that the local rule requires an application for withdrawal has to be supported and granted, quote, only upon a showing by affidavit or otherwise of satisfactory reasons. So you have to show satisfactory reasons, or, a showing by affidavit or satisfactory reasons, that there are sufficient reasons related to the protections afforded by the attorney-client privilege for brevity in my application for withdrawal. Okay, so this is fancy lawyer way of saying, Your Honor, take my word for it. There are reasons. I have reasons. There are reasons that are had. that I can't really go into too much detail here. And those reasons are related to attorney-client privilege. So, Your Honor, you got to take my word for it because I can't violate attorney-client privilege. But you got to take my word for it. There's reasons why I got to withdraw here. Here's my affidavit. I'm saying under penalty of perjury. Let me off this ride. Although I have provided Sean P. Diddy, Puff Daddy Combs, with the high level of legal representation expected by the court, under no circumstances can I continue to effectively serve as counsel for Sean P. Diddy, Puff Daddy Combs. I can't effectively serve as counsel. Under no circumstances can I continue to keep up my duty. I have a duty. I have a duty ethical standard. I have a duty to represent him to a certain level. I can't do it under no circumstances. Well, why? Why not? Take his word for it. Reasons that he got. But it has to do with, I can't say because attorney-client privilege, but take my word for it. There's reasons. And he ain't going to get good representation from me if you make me stay. The motion for withdrawal of counsel, if granted, will not result in any delay. So we're not asking you to push off the trial, Your Honor. It's not a ploy. Let me off. It will not delay the schedule, and it will not delay, the schedule for the commencement of jury selection and trial. Or it also will not delay the present schedules for briefing of pretrial legal issues. As a result, there's not going to be any lapse in representation because Diddy got all these other lawyers. He will continue to be represented by 5 other attorneys. Okay. And these are good attorneys. Listen, they are good. He says, without violating any aspect of the attorney-client privilege or otherwise providing any details whatsoever, I cannot provide any details whatsoever on the grounds supporting the application. The only hint we got in this whole thing was this was as a result of discussions with Mark Agnifilo. There's some attorney-client privilege at play. You're going to have to take my word for it by affidavit, but I cannot continue representing Sean P. Diddy, Puff Daddy Combs. I just can't. He's not going to be prejudiced in any way. He got a lot of other attorneys. I don't want to violate the attorney-client privilege. I want to keep that intact. I don't want to provide any details to anybody whatsoever. The government has been notified of the filing of the motion to withdraw. So I told them I'm going to be withdrawing. I didn't tell them any special secrets. They don't know anything other than that. The government takes no position on the motion seeking withdrawal. So they're not saying they're in support, but they're not going to oppose it. They don't care if this guy withdraws. This is another little hint right here. Look at this. And he even put it in italics to let us know he really meant for us to notice it. Or the judge, rather, to notice it, I should say. Wherefore it is respectfully, and look, italics, but regrettably requested. I'm respectfully, but regrettably requesting that the court grant me getting the hell up off Diddy's case. Please permit me to withdraw. Okay, and that's that. That's that on that document. So there was a few little hints, but truly, who knows? Who knows? Because he said he ain't telling nobody whatsoever, grounds never. He ain't saying. I don't even want to speculate. It could go either way. It could go a bunch of ways, not even just either. Okay, so that was document number 157. Okay. We're going to call it quits there for the day. As of the recording of this video, the live streaming of this video, we still do need to get through docket number 158 through 171. These were all filed since February 21st. It's going to include a letter from the government, from the feds, regarding the victims' names, releasing the victims' names. There's going to be a motion to suppress evidence filed by Diddy. There's going to be a memo supporting the motion to suppress. Teeny Garagos, Mark Garagos's daughter, submitted a declaration of sorts. The judge going to grant the motion for what's his name to withdraw. There's another sealed document in the vault. We're going to be talking about letter motion, oversized brief. That's just a technical thing. Memo. Okay, so the government's going to respond to that docket 153 or 152 where Diddy is trying to get the racist count dismissed or whatever. We're going to talk about that. The government did respond to it, so we'll talk about that memo. Order from the government, order from the judge is going to come up having to do with the victims' names. Another superseding indictment. That's S2. A letter. These 3 were filed yesterday. Actually, 1, 2, 3, 4, 5, 6 documents filed yesterday. But I wanted to kind of catch us up. Like, I didn't want to just jump on the most recent breaking news because, like, if you're only following my coverage, especially, you're gonna be lost. I would have been lost just trying to read that from scratch. I'm glad we did the catch up. Thank you for speaking the truth. Or just watch your last video. Keep your head up. Don't let people like her bring you down. You're amazing. Hit the like button. Yes. Thank you, Purple Jellyfish, for the 1999 super chat. And thank you for the words of encouragement. Yeah, so we're pretty much going to be able to get caught up to all those documents filed yesterday, either in the next video or the one after that, because it depends like how much attention I want to pay to that 153, that memo with the racist act and all that. Witness tampering, other hand. So this is going to be a letter motion. There's going to be a motion. Order. It's going to be an order based on the letter motion for the victims' names, the superseding indictment S2, a letter. Okay, right. So we'll get into that superseding indictment and how it differs from the S1. And then the government also is going to respond to that motion to suppress. Now, there's 2 different kind of motions going on by Diddy right now. A motion to suppress evidence, and this is having to do with a document we did not read. It's got a bunch of technical reasons. It was filed by Teeny Garagos, and now the government, is going to respond or has responded back and said their response to it. There's also, in addition to the motion for, it's confusing. In addition to Diddy's motion for suppressing evidence based on this compilation of reasons, he's also wanting alleged victim names, and he also wants to get rid of count 3 in the superseding indictment. I believe he still is trying to get rid of count 3. The superseding indictment S2 still does have the same count 3 as S1, as far as I could tell so far. So we will be able to catch up. We'll probably have to do at least one more video like this. And then I want to get into looking into some of the specific documents I think it's important for us to slow down and look at, like the motion to suppress, the memo on the motion to dismiss count 3. I do want to talk about that act. The witness names and the victim names and stuff like that. The differences between the superseding indictments 1 and 2. And I really want to get into superseding indictment 2, which was just filed yesterday. S2. It's worth its whole own video. So that's where I'm going to leave it off today, just so that we remember the last document that we looked at was the motion. The last document we'll call for this video is the Anthony L. Rico motion to withdraw as the attorney. That's document number 157. That's all I really had for it right now. In the meantime, facts ain't defamation. Love you, communicate. Bye.